The next case I'll be discussing is Valley Green Grow versus Charlton. The Valley Green Grow case is the first of two cannabis industry related cases that I'll be speaking about today. And I will touch base about another two cannabis industry cases that the SJC recently decided after press time. If you are a regular attendee of past DLS municipal law updates, this case might sound familiar to you. In 2019, I presented on a land court case involving different elements of this epic battle between the town of Charlton and Valley Green Grow over the development of a massive cannabis cultivation and processing facility. Now, after a state enactment of General Laws Chapter 94G, allowing the use and sale of recreational cannabis, Valley Green Grow, which I'll start referring to as VGG, purchased in Charlton a commercial fruit orchard containing 94.6 acres. VGG's plan was to construct a substantial indoor medical and recreational cannabis growing and processing facility on a property consisting of 860,000 square feet of greenhouses, a 130,000 square foot post-harvest processing facility, and a 10,000 square foot cogeneration facility to generate electricity and heat at the complex. The land court judge found that 86% of the proposed facility would be dedicated to indoor commercial horticulture. Now, observers in Charlton noted that VGG's proposal, at a cost of almost $100 million, would be one of the largest grow facilities in all of North America. Now, VGG's plan called for cannabis plants to be grown hydroponically without chemical pesticides in enclosed greenhouses that would maintain clean environmental conditions. In reviewing the land court's decision below, the appeals court here first addressed the regulation of cannabis industry in Massachusetts. It noted, as did the SJC case of Mederi Inc. versus Salem, which is the next case I'll be discussing, what is described as the unique interplay between state regulation, mainly through the Cannabis Control Commission, and local regulation of the cannabis industry. Under General Laws Chapter 94G, a municipality may impose reasonable local control over the time, place, and manner of a cannabis establishment operations, and a proposed cannabis establishment must comply with local bylaws and ordinances. Now, 94G requires an applicant to enter into a host community agreement with the town, setting forth the conditions for the operation of the cannabis establishment. Here, in the spring of 2018, Valley Green Grow filed a preliminary subdivision with the town, which under General Laws Chapter 48(6 triggered a zoning freeze for the site. Now, creating a zoning freeze entitles the property to have all zoning provisions in effect on the date of the filing of the subdivision plan remain in place. Simultaneously, VGG began negotiating with the town for a development agreement and a host community agreement. The town consulted with its building inspector, who gave an opinion that VGG's proposed use of the site and proposed purpose would be permitted as of right in the town zoning bylaws agricultural district. He also stated that VGG's other proposed uses were lawful accessory uses to the main agricultural operation. Now, the town and VGG thereafter negotiated both a development plan and a host community agreement. Next slide, please. Now, on August 14th, 2018, VGG applied to the planning board for site plan review as contemplated by the development agreement. On January 2nd, 2019, however, the planning board denied the application. In this decision, the planning board concluded that despite the contrary opinions of the town council and the town's building inspector, the proposed uses were not agricultural in nature, but really constituted light manufacturing which is a use that was not allowed in the agricultural zoning district in which VGG's property was located. VGG filed an appeal. In addition to VGG's appeal, another party filed a separate challenge to VGG in the land court, seeking a declaratory judgment that under General Laws, Chapter 240, Section 14A, that the town's bylaws use regulations did not allow for VGG's proposed use of the property. That party had also attacked the constitutionality of General Laws, Chapter 94G, which the land court determined was not within the jurisdiction of land court oversight. On appeal, the land court overturned the ruling of the planning board, holding that based upon accepted definitions of the word agriculture, the growth and cultivation of marijuana is within the plain meaning of the word. It is an agricultural use. It is not an industrial use. The judge therefore held that VGG's use was allowed as of right, and also that the proposed post-harvest processing facilities and the cogeneration plant were lawful accessory uses. Also, with regard to the second appeal, the judge ruled that because the town zoning bylaw table of uses did not mention specifically the word marijuana, that did not mean its cultivation was not allowed in town. Next slide, please. On appeal, the appeals court upheld the land court judge's opinion in both cases. The appeals court reviewed the town zoning bylaws and reasoned that VGG's uses were primarily agricultural in nature. VGG's proposed facility, the court held, was not light manufacturing, as the planning board had ruled, but VGG's uses were consistent with the zoning bylaws allowed uses as an indoor, light commercial, horticultural, floriculture establishment, and which were allowed by right in the zoning districts comprising the VGG property. The appeals court essentially ruled that the planning board, by denying VGG's plan, had overstepped its duties under the site review process, where its review had been limited to imposing reasonable on the proposed use. Also, the appeals court upheld the land court's determination that the post-harvest production and cogeneration facilities did not overwhelm the main use and were in fact lawful uses accessory to an agricultural operation. Despite the multiple lawsuits thrown at VGG that had been overturned, the opponents still have, Despite the multiple lawsuits thrown at VGG that had been overturned, the opponents still have at least one ace up their sleeve. And last month, the land court was scheduled to convene arguments related to a challenge to the zoning freeze protection that VGG acquired. So do stay tuned.